Welcome into Mock Trial Masterclass, your guide to controlling the courtroom. I'm Luke and I want you to be a mock trial master. Let's talk about how you can make that happen. So especially when you're new to mock trial, it can be easy to be overwhelmed with legal terminology. And one of the phrases that you'll hear a lot is burden of proof. And again, if you're new to this whole mock trial thing, I can understand how hearing a phrase like that would completely confuse you and make you think, okay, what in the world is that? So in this video, I'm going to explain what the burden of proof is. That way, from now on, when you hear that term, you'll be able to go, okay, so that's what that is. But not only that, once you know what the term means, you'll be able to use it effectively in your presentations. Sound good? Let's talk about what burden of proof is all about. So the burden of proof, in its most basic sense, means something very, very simple. It means the side in a case that has the burden, in other words, that has the responsibility to prove certain elements of the law in the trial. So, for example, let's say it's a murder trial and I am the prosecution. I represent the state or the government, and I'm bringing someone else to court accusing them of murder. Well, in that situation, the burden of proof, the responsibility to prove certain elements of the law is going to rest with me. So as the trial happens, it's going to be my responsibility as the prosecution, not the defense's responsibility to prove that they didn't do it. It's going to be my sole responsibility to prove that they did do it. Now, as you watch a trial, you're going to see a defense team or side in any situation trying to poke holes in the case that the other side is making. But at the end of the day, if the defense didn't even want to put on a case, didn't even want to call witnesses in real life, they wouldn't have to, because they don't have the burden of proof. See, that word again, that term, it just refers to the side that has the responsibility to prove certain elements of the law. That's the way we do things in the United States. When you bring someone else to court, whether it's a criminal trial like the example we just used, or a lawsuit, if I'm a plaintiff and I'm bringing someone else to court by suing them, it is my responsibility as the offense, if you will, to prove my case. It's not their side, it's not their job to prove that it didn't happen, whatever it is I'm accusing them of, whether that's killing someone, stealing from someone, or doing something wrong in any sense of the word. It's my job, it's my burden, it's my responsibility to prove that. So in its most basic sense, that's all the burden of proof means. It's the burden, the responsibility to prove specific elements of the law. For example, if you're in a murder trial, one element of the law is you got to prove someone killed someone, right? So when you have the burden of proof, it's your responsibility to prove those things. Now, that's not all that phrase refers to. There's a little bit more that we're going to get into in just one second. Before we get into the second half of what the burden of proof means, I want to remind you that you can schedule coaching with me. Look, I get it. This mock trial stuff is not easy, and even helpful YouTube videos like mine and that other people make sometimes aren't quite enough to get all that you need in order to excel in a tournament. So if that's the boat you're in, if you just want to take that next step and go a little bit further, I'd be happy to work with you. You can click the link in the description on YouTube or in the show notes on podcast platforms to schedule coaching with me, and I'd be happy to spend time with you or you and a teammate or you and your entire team going over anything you want. Just click that link, schedule coaching, and we can spend some time together. So not only does the burden of proof, that phrase, that term, refer to the actual responsibility, the actual burden to prove elements of the law, it also refers to levels of proof. And let me explain to you what that means. So picture you're a jury member in a trial, and at the end of the trial, based on the evidence you heard, you think it's probably 60% likely that the plaintiff's side was true, and 40% likely that the defense's side was true. So who would you rule for in that situation? Because in a lawsuit, you're going to be dealing with oftentimes really big money values, a lot of dollars being sued for, and so you don't want to make a decision too quickly, because even though over here you found a lot, you haven't found nothing on the other side. And so who do you rule for? What guides you in that situation? Let's make it a little bit more intense. Let's say you're in the jury for a murder trial and you're sitting there thinking that there's probably a 90% chance that the person did it, that they killed the other person. But something in the back of your head, about 10%, says, well, maybe there's a chance they didn't, because there's that one explanation the lawyer provided that really made a whole lot of sense, but I just don't know. Who do you rule for in that situation? Who are you supposed to rule for in that situation? Well, the burden of proof, that concept, can give you the answer to that question too. You see, the side that has the burden of proof not only has the responsibility to prove something, to prove elements of the law, but they also have a burden to prove it to a certain level. Their burden, their responsibility to prove something, is of a certain degree. There's two types of degrees in court, one for civil trials, for lawsuits, and one for criminal trials, where someone is on trial and has a chance to go to jail or to prison or to serve time in some other way. So let's break each of those two down, and we'll start with in a lawsuit. In a lawsuit, the burden of proof, the specific burden, the level that a plaintiff must prove their case to, is a preponderance of the evidence. Now, what in the world does that mean, right? Well, preponderance of the evidence simply means more likely than not. In other words, a plaintiff in a lawsuit just has to prove 51% to 49% that their side is right. A jury just has to believe that it is more likely than it is not that the plaintiff's side of the story is the true and accurate side of the story. And it's really not that high of a burden. Now, you can't just go around suing people, because it is still a burden. But in a second, when we talk about criminal cases, you're going to see that that is a much higher level to which a government or state lawyer has to prove their case. But within the context of a lawsuit, a civil trial, the burden of proof is preponderance of the evidence, which simply means more likely than not. Is it 51% over here, or 51% or more on the other side? That's what you're wondering, that's what you're concerned about as a juror. With criminal trials, it's a lot different. The burden that a prosecution side has in a criminal trial is beyond a reasonable doubt. They have to prove that the defendant did whatever they're being accused of beyond a reasonable doubt. What does that mean? Well, beyond a reasonable doubt simply means that there is no other reasonable explanation for the facts in the case other than that the defendant is guilty. So if you're in the jury in a criminal case, like the scenario we talked about a minute ago, and you go back to deliberate and you're sitting there thinking, okay, I'm 90% sure he did it, but there is this other reasonable explanation that very well could have happened, and if that's what happened, then he wouldn't have been guilty. He wouldn't have actually done it. Well, in that case, based on that standard of beyond a reasonable doubt, as a juror, you would have to rule for the defendant, because in that case, the prosecution did not meet their burden of eliminating all reasonable explanations aside from the defendant being guilty. Do you see how the burden of proof gives everyone a framework for what exactly needs to be proved and to what level on a trial? So again, at its most basic sense, the burden of proof simply refers to the side that has the burden or responsibility to prove the case, which in almost every case is going to be the plaintiff or prosecution. It can also, though, refer to the standard to which something must be proved. In a civil case, that being preponderance of the evidence, or more likely than not, and in a criminal case, that being beyond a reasonable doubt, or in other words, no other reasonable explanation aside from the defendant being guilty. That's how it works. So after taking this in, you might still be sitting there thinking, I don't quite remember all of that. I'm still a little bit confused. So feel free to rewind this video, start it back at the beginning. I think if you go through a couple of times, those gears will start turning and you'll start to go, okay, this is making sense. Feel free to talk to your coach too if you have one. I'm sure your coach can provide a lot of help on this topic as well. And if you want to schedule coaching with me to go over this or any other topic, remember to click the link in the description on YouTube or in the show notes on podcast platforms to do that. And so now that you're an expert in the burden of proof, now that you're a master of the burden of proof, you're well on your way to being a mock trial master.